So if I had to bet, I would bet on the landlord in this case.
Well, Lisa Vanderpump, her husband, Ken Todd, has been hit with nearly $1 million lawsuit for allegedly breaching his rental contract with the landlords of the couple's now closed Pump restaurant. So the company called 8948 Santa Monica Partners claims that Pump has failed and refused and continues to fail and refuse to keep and perform their lease conditions. Now, this is all according to documents that were obtained by Page Six. They are suing for $950,000 in damages after claiming Pump owes them roughly $250,000 in unpaid rent, $150,000 for their liquor license, and $50,000 in stolen fixtures. So the company has demanded $750,000 in damages for the alleged breach of contract and an additional $200,000 for allegedly not transferring over the liquor license, which was a value for $150,000. So Pump was supposed to turn the liquor license over. They didn't. And so they surrendered the property back in July. So this is a bit confusing because it was a rental property. So wouldn't it be the new company's responsibility to get a new liquor license, or does that just kind of fold over to the new owners?
Yeah, so there's a lot going on here.
Yeah.
And really, the terms of that commercial lease are going to control. So, there's three items of damages that are being alleged. So the Vanderpumps were renters; they didn't own the property. So this is here in West Hollywood, a few miles from where I live. Actually, by an aside, my wife's aunt is actually the mayor of West Hollywood, so I know the city really well. So when you're talking about a commercial lease, and if you terminate it early, you do owe that rent for the remainder of the lease. Now, the landlord has a duty to mitigate damage. That means to try to re-rent it, which it seems like they have, but they can collect the difference or the rent for any period where the property was vacant. Mm-hmm. Now, when you're dealing with liquor licenses, usually they're part of the property. You can't take your liquor license from Pump or Sur and just take it somewhere else. It's really, oftentimes it's grandfathered in, but it's really attached to the property itself, not with the renter. So obviously whoever rents that property is a prime location there on Santa Monica Boulevard in WeHo. They're going to want that liquor license because we know that restaurants, they make the majority of their income from beverage sales, including alcohol. And then the last issue are what we call fixtures. So there's a difference between furniture, things that aren't attached. You can take that with you if you're a tenant. So tables, chairs, those types of things. But if something's actually attached to the property, let's say a bar, for instance, that has to stay. So that's the difference between what tenants can take. And this is what applies to residential and commercial tenants. They can't take fixtures, but they can take other personal property that isn't attached.
Got it. So I think what they were talking about were either like lamps or fans or something like that. So if they wanted to take those and replace it with something else, could they have done that? So
it depends what it is. If it's like a fixture in the ceiling, it's attached, a fan, some sort of light fixture, that if it's physically attached, it has to stay generally. And if it's not, let's say it's a standing lamp or something, it can be taken. But sometimes, the lease will really carve out, this is part of the tenant's property and this is the landlord. So, absent any specifications as to what's a fixture and what's personal property, that's the general rule that applies. But otherwise, the parties can contract to say, hey, this belongs to the landlord and this belongs to the tenant.
Will Ken have to pay up?
Probably, if the landlord's allegations are true, again, commercial tenants have a lot less protection than residential tenants. And a lot of them, especially restaurants, really took a huge hit during COVID. So a lot of restaurants went under. I'm not saying that's the reason Pump has financial problems, but it's a very expensive part of town. I'm sure they were paying a lot of money per square foot, and there's really not a whole lot of defenses. So if I had to bet, I would bet on the landlord in this case.
For more news content and exclusive interviews, make sure to hit the sub, like, and bell button down below and visit usmagazine.com.